91.3 WLRN presents Topical Currents. Today's program centers on the Florida criminal justice system, especially in the areas of youth and mentally ill inmates. Good afternoon, Joseph Cooper, Bonnie Berman. Although they are convicted of a crime, it doesn't take much to know that housing youthful convicts with adult prisoners can come to little good. Florida leads the nation in the number of such cases. As social services and treatment funding erode, more and more inmates diagnosed as mentally ill wind up in general prison populations. We'll learn more from the Center for Children's Law and Policy staff attorney Jennifer Lutz. In our second half, we turn to mental illness and prison sentences with psychotherapist and former Florida Department of Corrections psychiatrist George Mallinckrodt. That's next. Stay tuned. First News. And we return 7 minutes past 1 o'clock. It is today's Topical Currents, Joseph Cooper and Bonnie Berman. Well, this hour we discuss the Florida criminal justice system and how it incarcerates youthful offenders and those diagnosed with mental disorders.
We'll learn more from staff attorney at the Center for Children's Law and Policy, Jennifer Lutz. Later, we'll speak with former Florida Department of Corrections psychotherapist and whistleblower George Mallinckrodt.
First, though, attorney Jennifer Lutz leads a campaign to end the practice of solitary confinement of youth and also to reduce racial and ethnic disparities in the juvenile justice system. She joins us now from Washington, D.C.
Welcome, Jennifer.
Hi, how are you?
Good, how are you?
Great, glad to be here.
Good to have you. Just for clarification, incarcerating individuals under the age of 18 with adult prisoners and trying them as adults is determined by each state?
It is determined by each state. Most states have different policies or statutes allowing them to charge youth under a certain age or over a certain age, rather, or who are charged with certain offenses to automatically or through a judicial process to try them as adults. Whether or not that state decides to hold those children who are being charged as adults in adult facilities or in juvenile facilities while they're awaiting trial varies from state to state. There is federal legislation, though, that youth who are held in adult facilities are not allowed to be held in the same cells or to have sight or sound contact with adults, but they oftentimes are housed in youth areas of adult facilities, and they, again, are going through the process of the criminal justice system just as an adult would because they're being charged as adults.
Is the most common national age 18?
For being charged as an adult or for being in an adult facility? I honestly don't know what the average is. I know that many states permit children over the age of 14 or 15 to go through a process where they are certified, or either if they're charged with a certain type of violent offense, to be automatically charged as an adult. Then other states, like North Carolina, have a very low age of jurisdiction for adult court. So if you're 16 and you're charged with a crime in North Carolina, you're going to be charged in the adult system. So the age really varies from state to state, and whether or not we're talking about the age of majority, so when someone automatically is charged as an adult, and then the individual state practice on how to charge someone who is otherwise a juvenile as an adult.
Exceptions.
So it often happens before 18.
So is this only for felonious crimes of a certain nature? Is it for violent felonies? Is there one type of crime that's the criterion for them being charged or tried as adults?
I think that, and I can't speak to the entire national policy, predominantly the work I do is within the juvenile system, but I think that the majority of states, it's either determined by age or a combination of age and offense level. So in many states like Pennsylvania, if you're 15 years old and charged with a first-degree felony with a deadly weapon, you're automatically going to be charged as an adult. However, there is a procedure through which the district attorney can charge a child even younger than that, age 14, can move the court to try that person as an adult, and that could be for much lower level offenses. So I'm sorry, go ahead.
No, you go ahead. Please finish.
But I think that generally it is often tied to serious offenses, but it is also very possible through different judicial processes in different states for children to end up in the adult system who are not necessarily there for the most or the worst of the worst crimes.
I suppose it's difficult to have a generality, but how does the transition from juvenile to adult occur of those convicted?
I honestly, what do you mean by how does the transition happen once they're convicted?
If a juvenile is convicted as a juvenile, once he reaches adulthood, or he or she, do they transition into the adult sector?
Yes, in the majority of states they do. Some states have a correctional facility or one prison that has a wing where they keep kids up until maybe age 21 or 24. And again, that's only some states. I can't speak to it's hard to speak in generalities. But generally, once someone who was under the age of 18 when they committed an offense or were found guilty of committing an offense and is charged in the adult system, once they turn 18 or, if it's 21, 24 in various states, they will transition to being housed as a prisoner in the adult system, in the adult prison system.
I read this. Who determines, when I asked about the criteria for charging a child as an adult, is it a judge that says we're going to try this person as an adult? Is it an attorney that says that? Is it the prosecutor? Who decides?
It varies from state to state. Some states, again, there's legislation that's actually been passed that says if you are of this age and you are charged with this offense, you will automatically fall under the jurisdiction of the adult court. In some of those states, there is a reverse transfer mechanism where you can have a hearing in front of a judge and try to argue to the judge as an attorney why your client is better suited and why the community is better suited to have that child tried or treated in the juvenile system. In other states, there is a great deal of prosecutorial discretion, so the district attorney can decide whether or not to try a child as a juvenile or as an adult. And then again, there are various legal motions or hearings that a defense attorney can try or file and go through to try and have a juvenile brought back to the juvenile system. So the decision, often it's the judge, sometimes it's the district attorney, sometimes it's statute.
What are the benefits? Let's just talk about what is the difference between being placed in the juvenile justice system versus the state Department of Corrections for adults for a child?
I think that the benefits are huge. The juvenile system is designed to not exclusively focus on rehabilitation, but to predominantly focus on meeting the rehabilitative and treatment needs of that child based on what their offense was. And most states do factor in within their juvenile systems some way to account for, the community protection, taking into consideration what the offense was, so it's not totally focused on that kid's needs, but as opposed to the adult system, which is focused on deterrence and retribution, are all kind of concepts that come into play in adult sentencing. So if we're talking about a young person who has committed an offense, and I think that, I am definitely of the view, and many people are, that it's not just the natural state of any child, especially young ones, often at the age of 10 to 13, to commit an offense, that we generally have to look at what else is going on in this child's life and what are the needs at play that led for this to happen. Why did this happen? What were the failings? And the juvenile system is much more equipped to look at those, and then through services, intensive probation if need be, and even treatment within juvenile facilities to address those needs. The idea being that all of these, virtually every juvenile offender will at one point leave the juvenile facility and come back into the community, and they're basically, they're children, they're our children, and we want them, to get treatment. That happens most effectively in the juvenile justice system as opposed to doing a sentence or doing time in an adult facility.
Jennifer Lutz, could you give us some examples of specific adolescents around the country that the Center for Children's Law and Policy finds most objectionable in their treatment?
Finds most objectionable to, I'm sorry.
To the treatment of being convicted as a juvenile, and what kind of objectionable treatment they are most subject to. Some examples.
So objections,
some
the
examples.
ones we don't want to end up in the adult system.
Yes, some examples.
I think, well, generally, I mean, I can talk a little bit also about the work that we do, but the ones that, we think would need to be kept in the juvenile system most are the most vulnerable kids, and that includes those who have experienced trauma, violence in their past, those children who their offenses, and we don't do direct representation, so I can't give you exact examples of specific cases, but generally kids who come from backgrounds of trauma and who are there for fairly minor offenses. The types of crimes that we see adolescents being charged with are very different than adult types of crimes if you consider kind of what the motivations were. We all know that teenagers and kids are different than adults, and generally the types of offenses that we see really reflect that. If I had police reports to read to you, they would generally be things that many times you would say, what were they thinking?
Such as what?
You think, I'm trying to give you. I was a public defender in Philadelphia for 10 years. So, for example, a lot of property crimes. So stealing things from stores when it's very clear that you're going to get caught. Such as thinking it's a good idea to break into an abandoned house to smoke marijuana with your friends, not understanding that that's a burglary charge, thinking that might be something that's harmless, not really understanding fully the consequences of that. So kind of typical teenage behavior that often intersects with the justice system in such a way that it leads to charges. This is our expertise or my expertise rather is kids in the juvenile system, and that is different. Many kids are arrested in school, and often they don't end up in the adult system, but they do end up deeply entrenched in the juvenile system for school-based offenses. So things that, when I was growing up in a smaller town in the South, I would never have been arrested for. So I know that is not giving you specific examples, but rather some generalities of the types of offenses that we like to see out of the adult system.
Okay, well, I have some. You are involved in this campaign against the solitary confinement for juveniles, but we need to take a short break. We're speaking with Jennifer Lutz, staff attorney for the Center of Children's Law and Policy, and we'll take this break. We'll be right back.
And we're back with today's Topical Currents. Joseph Cooper, Bonnie Berman. We're speaking with staff attorney at the Center for Children's Law and Policy. She's Jennifer Lutz. And if you'd like to join in with a comment or a question, you're certainly welcome. Our number, 1-800-743-9576. 1-800-743-9576. Also email, that's radio@WLRN.org, radio@WLRN.org.
So, Jennifer, this solitary confinement is yet another issue for juveniles. It looks like up to 17,000 juveniles are in solitary confinement, which has been shown to lead to depression, anxiety, mental illness in children. So what's being done to change that?
Well, there's a lot being done, and you're right to say that there are huge numbers of kids in solitary confinement within the juvenile system in our country, and it has been shown to have super harmful consequences for kids, mental health issues, re-traumatizing kids that already have trauma in their history. Right now, there's a lot being done across the United States to address solitary confinement. The majority of that is happening on the adult side. So my organization, the Center for Children's Law and Policy, along with 3 other national organizations, are working on creating a national campaign to stop solitary confinement for kids. There's a lot of disparate efforts that are happening in various states across the country. Some are happening through policy, some are happening through legislative changes, and some are happening through litigation. Ohio is a state where there was recently litigation surrounding solitary confinement for kids. So there's a lot going on nationally. In terms of what are best practices, there are 2 primary best practice standards for kids who are in custody or in facilities, and those are the JDAI standards or the Juvenile Detention Alternative Initiative standards, which are created through the Annie E. Casey Foundation. Those are used in over 250 sites across the country. Those address solitary confinement, as well as a set of standards created by the Council for Juvenile Correctional Administrators. And so those are standards of best practice created by those who are in charge of juvenile detention facilities and correction facilities, so rather standards from insiders. Both those national standards address solitary confinement and say that solitary confinement should be something that is used never for punishment, but only in situations where a young person is out of control, threatening, or is posing a risk of injury to themselves or someone else. And really, as a cool-down period, they can be removed and placed in a room. But that should really only be for minutes or at most hours until they're no longer a threat. That should not be something that happens, again, as punishment for a minor rule violation, and it shouldn't be something that lasts days or months. And there are places in this country where we are putting children in rooms, and again, this is not like going to your room where you have, books and comic books and a TV and a nice room that many kids who are on the outside have. We're talking about a 6 by 12 foot concrete room, often with nothing in it, where we're putting kids for hours at a time.
Like it would be for an adult prisoner.
Like it would be for an adult prisoner. I mean, often it's not quite. I can't speak to the conditions at places like Rikers in adult prisons, but we are talking about isolating a kid in a room and behind a locked door, concrete walls, very sparse conditions. Sometimes that is even their own sleeping room. But I think that if you think about going into a space like even your bathroom or a very small area, taking away everything that you would normally look at, magazines, things like that, and just think about sitting in there for an hour, what that would be like. And that is essentially what we are asking kids to do for 6, 7, 8, 23 hours a day. And part of the problem is that not only that this can cause extreme psychological harm, trauma for kids, but that ultimately it doesn't help. Kids who are placed in solitary confinement and often in juvenile facilities across the country, that's called lots of different things. Part of the reason why it's difficult to get consistent national data on this is because solitary confinement is often called things like administrative segregation, room time, temporary separation. There's all kinds of different names it's referred to.
What forces most want this blocked, Jennifer?
I mean, I think it's a combination.
Who fights against the center and the other organizations in this idea to end solitary confinement for adolescents?
So in other words, who's saying, no, we want to keep solitary confinement?
Who's fighting?
I mean, I think that the majority of the opposition that we see nationwide comes from either corrections unions, staff unions, people who work in facilities, or probation unions. That's the case in California. There is some pushback there. And I think there's a good reason for that. And I think that part of, at least through the campaign that we are creating called Stop Solitary for Kids, we have to address what that is. I don't think that anyone, any rational person thinks, yay, let's put a kid in a room, solitary confinement, how much fun and how great for everyone. I think that the problem
We're just not wired for that. Humans aren't wired for that.
We're not wired for it, and I think that most people who work in facilities also want to help kids. I don't think that anyone working in facilities who actually, the staff and administrators that are actually putting kids in solitary confinement do so because it makes, that they're malicious in any way. I think it is legitimately a concern for their safety. Solitary confinement, it has long been used within juvenile facilities as a behavior control tool. It is often the most frequently used behavioral tool. If a kid is acting out, being violent, which often happens within facilities because we're talking about kids that have significant behavioral and mental health issues, it's very easy to say, you know what, we need to separate them and we're going to put him in a room and he's there until he calms down. But often that doesn't happen for many. Solitary confinement doesn't really work that way. So I think that when we talk about saying stop solitary confinement, we often get the pushback that we're removing a tool in people's toolkit. In other words, the staff's toolkit. And I think that's a legitimate concern that they have. It is a tool. I would argue an ineffective tool. But I think that the most effective way to reform the use of solitary confinement in juvenile facilities is to work on more comprehensive ways to give staff other mechanisms to use. We know from states like Ohio, like Massachusetts, those are states that have drastically reduced the use of solitary confinement, and they don't use it for punishment any longer. That this is not pie in the sky, that there are ways to actually keep facilities safe, keep staff safe, keep kids safe, and not use solitary confinement. So our national campaign is focused on incorporating those perspectives of organizations or unions of staff. There are many that actually support eliminating or reducing the use of isolation or solitary confinement, and focusing on those strategies, those tools that we can actually give those opponents, if you will, of reducing solitary confinement to say this works instead.
Jennifer, I wanted to ask, and this will lead to our second guest. It just seems to me, listening to this, that maybe a lot of these kids have mental issues and they're not diagnosed. Is that a problem? How is that addressed? How is mental illness addressed in the case of these juveniles that are either sentenced in juvenile institutions or those especially tried, sentenced, and incarcerated in adult criminal justice system?
So you're right that often a lot of what we see, the behavior that we see, that both leads kids to having contact with the juvenile justice system, and then once they're reflected in their behavior when they're in a juvenile justice system, whether it's on probation or in a facility, is an effect or is a manifestation of significant mental health issues. There are various statistics out there that say that 70% of kids who enter the juvenile justice system have some degree of mental health disorders, most of them having something that could actually be diagnosed as mental illness. So in the best juvenile facilities, and we would like to think of a juvenile facility as being the end point or the last resort of a juvenile system that should be, in terms of a court system, looking at how they can get kids services in the community, how things like how mental health examinations can be given early on so conditions can be detected, and really so that a system can respond to the kid or a youth in light of someone who has a mental health issue, not in punitive ways, because often a lot of the mental health disorders that we see in young people manifest in ways that appear like defiance.
So is that being addressed?
I think that in many states it is. I think that there's a lot of states have a long way to go in terms of addressing that in the courts and then addressing that within their facilities. In other words, when a youth comes to a facility, they should receive a mental health evaluation within almost immediately upon entering, so the staff in the facility understand what they're dealing with and can design programming and treatment effectively. Unfortunately, many facilities and systems, probation systems, don't have the resources and aren't really equipped to provide qualified mental health professionals to interact and be part of a kid's treatment and programming,
Jennifer,
whether they're on probation or in treatment.
And I'm just wondering why they'd be sentenced in, incarceration instead of in getting mental health, like being in a hospital. But anyway, I guess
where can people get more information?
They should be. You're right. They should be.
Yeah.
Where can people get more information about the Center for Children's Law and Policy?
You can visit our website, which is www.cclp.org. You can also, if you're interested in more information on youth charged as adults, you can visit the Campaign for the Fair Sentencing of Youth, so that's probably the best place.
There's also
if you're interested in
that Campaign for Youth Justice as well.
And the Campaign for Youth Justice, which has a lot of resources for people who are interested in furthering that discussion about youth in the adult system and their treatment there.
Okay, well, thank you, Jennifer Lutz, staff attorney for the Center for Children's Law and Policy. Prior, she was the Juvenile Justice Policy Attorney and Director of Juvenile Training at the Defender Association of Philadelphia. Thanks so much for being with us today.
Thank you so much for having me.
Our pleasure. When we come back, we'll visit with George Mallinckrodt. Stay with us. And welcome back to today's Topical Currents. Joseph Cooper and Bonnie Berman. We now focus on Florida's criminal justice system. We're joined now by George Mallinckrodt.
He's a former Department of Corrections therapist who served on a psychiatric unit in the Florida State Prison System. He's also an author, having written the book Getting Away with Murder, A True Story.
It tells of his 3-year experience working within the system he grew to abhor, and later after his later firing.
More on the book topic a bit later.
Welcome, George Mallinckrodt.
Thank you. It's great to be back on.
It's good to have you on. So last time you were here, we were discussing the first edition of the book. And it discusses the story of Darrell Rainey, the story of his death at the Dade Correctional Institution. We'll get more to the book later. But since that time, the Dade County Medical Examiner has ruled Darrell Rainey's death accidental, that he died from complications of schizophrenia, heart disease, and confinement. Your reaction to that?
Well, I'm very disappointed. This is now 3.5 years later, and actually 3.5 years after I found out about it. And early on, I reached out to the medical examiner's office on several occasions, only to find out that the report was pending. And after about a year and dozens of calls, I finally spoke to Dr. Emma Liu, who performed the autopsy. And I filled her in on the details of what was happening in the unit and the brutality and the abuse.
And you're talking about the transitional care unit at the Dade Correctional Institution.
Yes, that psychiatric unit inside the state prison. So I was shocked when I heard that they found it was an accidental death, and the idea that they pretty much went along with the guard's story about what had happened, which is sort of like, well, we put this guy into the shower and we came back later and, oh my God, he was dead. We don't know what happened.
And yet they acknowledged it ran 2 hours in the shower.
Yes.
And that his skin sloughed off.
Right, from warm, moist conditions. No.
Why did it take 3.5 years?
You'll have to ask the medical examiner. And I told Dr. Liu, I said, listen, I work there, and I can tell you that water was boiling hot. And how they came to the conclusion that it was his skin had sloughed off from apparently warm water, I can't answer why it's taken 3.5 years. I have no clue. And a lot of other people have questioned that as well.
Well, Julie Brown wrote an article, I guess a week after the report was issued, and she questions the report. Let's talk about her article, if you remember it.
Yes.
First of all, she cites former chief medical examiner, I forgot his name, in New York City. Do you remember his name?
Not offhand.
Okay. Who questioned this autopsy report.
Yes, so here's a man who's done autopsies for 30 years, and he questioned 3.5 years later, and he suggested that was indicative of a cover-up, and I'd have to agree.
And he also said something about how you don't die from schizophrenia.
Schizophrenia, yeah, that you don't die from
and
that.
your skin doesn't slough off.
Exactly, because he made the point that if that was the case, then if we took a bath, everybody's skin would be sloughing off.
Well, it looks like the ACLU is moving to have the Department of Justice investigate. Where does that stand?
Well, the Department of Justice announced, I guess it's now about 6 or 7 months ago, that they were opening a criminal investigation into the death of Darren Rainey. Now, here's something that I don't think listeners know. Within 2 months of me finding out about the scalding death of Darren Rainey, I had a sit-down, face-to-face meeting with FBI agents, and I filled them in on all the details that we were to find out in the Herald 2 years later. So 2.5 years after I spoke to these FBI agents, the Department of Justice decides they're going to open a criminal investigation. We have not seen any results yet. This is now 8 months after they announced it, and we're disappointed. We're wondering why it's taking so long, and there are no answers.
And nothing at the state level.
Nothing. In fact, a group that I'm affiliated with, Stop Prison Abuse Now, met with Catherine Fernandez Rundle back in October of 2014. And we asked, we said, what could we expect within 3 months? And she said, oh, no, we're going to have something in 3 or 4 weeks.
That was a year and a half ago?
Yes.
So have you been back in touch with Catherine Fernandez, with her office?
Not me personally, but other members of SPAN have reached out to find out if there's been any movement, and so far, nothing's happened.
Let's move along a little bit and expand our conversation and talk about mentally ill convicts in the Florida prison system and their lack of treatment and what can be done about it.
Let me ask, and let me add to that the same question I just asked Jennifer Lutz. Why are they incarcerated with criminals when they're mentally ill? Why aren't they in hospitals?
Right. There's a lot of reasons for that. What we can do right now for the people that are incarcerated needs to be vastly improved. And statistically speaking, about 17% of all incarcerated in jails and prisons suffer from severe mental illness. That's about 400,000 people across the country. Now, if you take that to Florida, which I don't believe there's any reason why that wouldn't be true here, given a prison population of 100,000, that means that there are 17,000 people that suffer from severe mental illness in the Florida prison system. We do not have 17,000 psychiatric beds in Florida. And some of these people do cycle in and out of psychoses. And what happens typically is guards can't recognize the difference between a standard behavioral outburst and a psychotic episode. So these people who are severely mentally ill often are thrown into solitary or closed management, as it's known here. Jennifer was noting all the different names you call things. Closed management is where they end up. That's solitary.
Those are euphemisms.
Yes.
Which could lead to more mental illness.
Exactly. That's contraindicated for people suffering from severe mental illness. And so we don't have enough psychiatric facilities within our system here in Florida to manage this population. And approximately 5% of all inmates are experiencing active psychosis. And I can tell you that there are not 5,000 psychiatric beds to handle them either.
And I would assume the guards are not they're not healthcare professionals. And as you say, they can't recognize the difference between a behavioral outburst and a psychotic episode.
Yes, that's true. And there's been some movement to provide what's called CIT, which is crisis intervention training. And there are various levels of that. I'm not sure that guards are getting the full 40-hour course. There are 8-hour courses, and not all guards in the Florida Department of Corrections have had it. And then in the background is the specter of this culture of brutality. And I'm going to say right now that there are a number of really good correctional officers, true professionals who do their job, and my hat is off to them. These people deserve our respect. This is a thankless job. However, there's a minority of correctional officers and administrators who think the means to control the population is through force, through brutality.
The mentally ill population.
Anything,
population.
anything.
Okay.
And so the point here is we can train those people as much as you want, but they're pretty much going to ignore the training.
Because of the lack of mental health facilities that have been shrinking over the decades, and also the few treatment methods within the prison system, does that weight diagnoses or treatments to a pharmaceutical answer?
Well, certainly pharmaceuticals can help. I had a number of people on my caseload. I had a man, for example, who was paranoid schizophrenic, and he was eating his own feces. And once we were able to get him on the appropriate medications, it's like you and I speaking now. It was the first time I'd worked with somebody suffering from schizophrenia, and I thought, my God, this is a chemical miracle. And certainly that is one of the tools in the treatment toolbox.
Well, I read that states including Texas, Georgia, and Mississippi have begun reforming their criminal justice and sentencing systems to stop using prisons to incarcerate the mentally ill. So what about Florida?
It's even been bipartisan to some extent.
Yeah.
Yes, absolutely, because these states are finding out that this is a very costly proposition. It costs much more to incarcerate somebody and attempt to treat them for their mental illness as opposed to having them in a residential treatment facility. It's generally twice as much. So this is what we need to put in place in Florida as well. And we're seeing some of that, for example, with the program that Judge Steve Leifman is so well known for in Dade County, the jail diversion program. But at some point, we need to start looking at what happens much, much earlier in a person's life.
Okay, we're speaking with psychotherapist George Mallinckrodt. He's the author of Getting Away with Murder and now a second edition of it. We'll take a short break. We'll be right back.
And we're back with today's Topical Currents, Joseph Cooper and Bonnie Berman. We resume our conversation with George Mallinckrodt. We're talking about mental illness and the Florida State Prison System. If you'd like to join in with a comment by phone, 1-800-743-9576, or email, that's radio@WLRN.org. George Mallinckrodt, in your view, what could alleviate the suffering of so many people who desperately need treatment and yet are serving really stiff prison terms?
Well, it really comes down to programs of early intervention. We have little in the way of mental health safety nets for our children, adolescents, and young adults. And 50% of people who are suffering from mental illness had signs by the age of 14. So this is a population that is vastly underserved. And another job that I had was actually in the Dade County public school system. And I worked for a program that's no longer in existence. It was the Bertha Abbas Children's Center. And they had a program that targeted middle school children that suffered from severe mental illness. We're talking major depressive disorder, obsessive compulsive,
schizophrenia,
and even schizophrenia. I had a 12-year-old girl on my caseload that had been on psych meds for hearing voices for 2 or 3 years. Until I started working for that program, I wasn't aware that children that young could suffer from schizophrenia. And so it was an eye-opener. Not
to mention bipolar.
Absolutely.
Disorder.
I had several on, and we're talking, I also had bulimics, cutters, anorexics. I saw quite the range.
Well, so what, talk about this. There are two groups that are going to be rallying in Tallahassee, called the Rally and Tally. First, tell us about the group that you mentioned that you're affiliated with, Stop Prison Abuse Now, or SPAN.
Right. Stop Prison Abuse Now was started very shortly after Darren Rainey's death. I met with a group from the Key Clubhouse of Miami, and that's where the group was born, in that meeting. And since then, it's expanded. Its membership is expanded. It's very active in criminal justice reform. We are affiliated with the ACLU. We're in contact with Howard Simon. We are dedicated to changing the system. And so they're one of the groups that's part of this rally in Tally. And the name of the rally is Justice for Those Who Have No Voice. And we'll discuss on the Capitol steps a number of topics. Why this glacial pace of investigations. We've heard so many stories from the Miami Herald, at least 17 very suspicious deaths. We're not hearing any resolution there. People will talk about alternatives to incarcerating the severely mentally ill. So it's going to be a rally that we're hoping that will get a couple hundred people.
And when is it?
That's going to be March 7th, and that'll be 10 a.m.
To
4.
Okay.
How does privatizing prison functions figure into some of this?
Well, that's not actually been a very positive development. I worked for a company called Horizon, and that's a private company, and they provided mental health and medical services. They have over 600 malpractice lawsuits pending, and the Miami Herald and specifically the Palm Beach Post detailed a number of examples where their nurses and doctors denied medical treatment to people suffering from very severe physical illness. And so this has just not been a very positive a thing for the inmates that are desperate for treatment.
Let's talk a little bit about a couple of things. One, about your second edition of your book. What is going on with that? You say it's banned now, the Department of Corrections?
Yes, it is official as of a couple of weeks ago. The department sent an attorney from the ACLU a letter basically saying, well, your content of the second edition was a little different than the first, but it's banned for the same reasons.
Getting away with murder.
Getting away with murder. And what they said was that it could cause a prison riot. And I didn't advocate any sort of thing in my book at all. And they called it dangerously inflammatory. And all I can say is the inmates within the Florida Department of Corrections would learn nothing new from my book.
They're living it.
They're living it.
So just so for our listeners that don't know, Getting Away with Murder was the story of your working at the transitional unit at the Dade Department of Corrections, and the story of Darren Rainey's.
Yes, that's correct.
Death.
And the book sort of has two themes through it. One is my work there in the unit, and then the second one, all the steps I took to get Darren Rainey justice.
What's his family doing now? I mean, are they pursuing any legal action?
Yes. I spoke to Andre Chapman, his brother, last year, and what I've learned is they've moved out of Florida, and they are working with an attorney from L.A. on a wrongful death lawsuit. And honestly, Andre was very deeply disturbed by the lack of a report from the medical examiner's office. And, you know, they've now waited 3.5 years to get word that this is an accidental death.
With that accidental death ruling in place, it would seem very difficult to make major challenges to that case.
Well, that's really for the attorneys to figure out, so that's a little beyond my realm of expertise, but one would think so.
I just want to say I was very surprised at this. I don't know if you mentioned this in Getting Away with Murder, but it is in the Julie Brown article that the reason that Darren Rainey was in prison is because he had the possible possession of cocaine.
Yes.
What does that even mean, the possible possession? Why would he have been in prison?
I don't know about that, but I did read somewhere else that he got 2 years for 2 grams of cocaine. And, you know, this also calls into question sentence disparity. And is that really a correct sentence for 2 grams of cocaine? This is a man who is mentally ill and had a drug problem. He should be in a treatment facility, not prison. And what happens in our society is we are criminalizing mental illness. And in Darren Rainey's case, it was a death sentence.
I suppose for people who are addicted to drugs and wind up in prison, they go through withdrawal symptoms with very unsupervised methods.
Absolutely. And I'm wondering what kind of treatment they have for those people as well. We didn't have any people who were recovering addicts in the units, so I couldn't speak to that directly.
In the transitional unit.
In the transitional care unit where I worked, yes.
Yeah. Well, again, tell us about this tally and rally in the last minute. And
Rally and tally.
The rally and tally.
What did I say? Tally and rally? Okay, the rally and tally.
Yes,
it's you and Forgotten Majority.
Yes, the other group is Forgotten Majority. Forgotten Majority is a prisoners' advocate group, and they actually get a number of letters, actually quite a few letters every year, along with phone calls from contraband cell phones, where the inmates detail not only the abuses they suffered at the hands of the officers, but the names of the officers as well. And since 2011, there are an estimated 300 officers named, and we're not talking about minor abuse. We're talking about beatings. We're talking starvation. It's some pretty serious stuff.
So the rally in Tally is Monday, March 7th. It's at the Capitol Courtyard in Tallahassee, and it starts at 10 o'clock. How do people get in touch with you that would like to?
Well, the best way is to go on my website, georgemallinckrodt.com. And there is another way that's even easier. I just got this domain name, gettingawaywithmurder.org.
It's easier to spell than George Mallinckrodt.
That's true. Gettingawaywithmurder.org.
Well, the best to you and your mission here, and
thank you.
Psychotherapist George Mallinckrodt, the author of Getting Away with Murder, his account of the treatment of the mentally ill that he witnessed while working in the state prison psychiatric ward at Dade Correctional Institution. Thank you, George.
You're welcome. Great to be here.
And thanks for being with us. The program was produced by Richard Ives. Technical direction from online producer Paul Leary. Polly Landis is associate producer. We have free audio archives for download at our website. That's WLRN.org. Tomorrow, Bonnie and I discuss tangible results of seawater rise, especially in Miami Beach. They're pumping back bay water after storms. We'll visit with Elizabeth Colbert, staff writer of The New Yorker, as well as University of Miami geology professor Harold Wanless. The Siege of Miami. This is Joseph Cooper with Bonnie Berman. Stay tuned for Here and Now, next from NPR News.